Okay, we all set on at 7:30. Jeffrey, you all set on that one? Great.
I am ready.
Mr. Sheffield, are you all set?
I am, sir.
Okay. Ladies and gentlemen, we're going to call to order our first hearing of the evening. This is on the application of Charlie Downey. The application is dated February 15th, 2013, and Mr. Downey is seeking a variance from the terms of Section 61 of the Milton zoning bylaw. He's seeking to build a new single-family home on a vacant lot located at 390 Brook Road in Milton. It's shown as Lot 30 on the Milton Assessors plans, and the lot is located in a Residence C district. The new home is proposed to be 10 feet from the rear property line instead of the 30 feet required by Section 61. My name is John Leonard. I'll be chairman for this particular meeting. With me this evening, to my immediate left, is Board Member Jeffrey Mullen, and to my immediate right is Board Member Nick Gray. The rules of the board are going to be such that we'll first hear from the applicant, who's represented this evening by Attorney Robert Sheffield of 553 Adams Street in Milton. And then we'll hear from any persons who have questions of the applicant or Mr. Sheffield. And then we'll hear from other persons who wish to speak, including those, if any, who wish to speak in opposition to this variance application. In addition to the advertisement, which I've summarized, we have the application of Mr. Downey dated February 15th, 2013, which we will have in evidence at this particular hearing. We have a denial letter from Joseph Prondek, our building inspector, dated February 15th, 2013. We have a letter to Mr. Prondek from Robert Sheffield, Mr. Downey's attorney, dated February 12th, 2013. And the applicant has filed with us a plot plan of land. It's entitled Proposed Dwelling Located at Brook Road in Milton. It's by DeSell and Burke. It's dated January 30, 2013, and it shows the subject property and its relation to Brook Road, the proposed location of the new dwelling, and the rear property line of adjacent properties that may be relevant to this application. So we're tape recording the proceedings this evening, so that would ask that before anyone speaks, tell us your name and address. Speak up nice and clear and loud. We have a small room here, but sometimes the acoustics aren't as good as we wish. And if we have to resort to the tape recording to write a decision on this particular application, it's important that we be able to identify those people who speak at the public hearing. So without further ado, Mr. Sheffield, welcome back to the Board of Appeals. It's good to see you again.
Thank you, Mr. Chairman and members of the committee. I am Attorney Bob Sheffield. I have offices at 553 Adams Street in East Milton, also reside in Milton. I'm pleased to represent Mr. Downey, who is purchasing the property, and he will be purchasing it with his partner, John Abdelahad, who is also here this evening. The property is a rather unusual tract of land that is at the on Brook Road, and it is nearly across from Lincoln Street. It contains about 15,200 square feet, and it is unusual because it owns to the center of the brook, Pine Tree Brook, as that brook existed in 1937. Due to Hurricane Carol in the 50s, the brook and the path of the brook was modified so as to reduce the flooding which occurred during massive rainstorms. So that now some of the properties that are located on the street behind it, Russellwood Road, actually own a little bit of land on the Brook Road side of the Pine Tree Brook. This case, this property came before the Board of Appeals back in 2007 when we wanted to transfer the rear line to the middle of the brook as it exists now for the property that is located at 50 Russellwood Road. It was necessary to come to the Board of Appeals because the frontage was somewhat less than 75 feet, so therefore it was a pre-existing non-conforming lot, which can only be modified with permission of the board, and the board granted a variance at that time. So now the Brook Road lot owns to the center of the brook as it now exists for the property behind 50 Russellwood. I will give you the same.
Thank you, Mr. Sheffield.
I passed out a sheet which is similar to the sheet that accompanied the application, but it shows in yellow the small triangular portions of land owned by the Russellwood Road property owners that are on the southern side of the Pine Tree Brook, and that is the Brook Road side. There is two properties that own land on the Brook Road side of the brook. One is to be located approximately 10 feet from the proposed building, and the other, no variance is necessary because it is more than 30 feet between the proposed building line and the property line. If the property on Russellwood were not registered land, it would not be as problematic, but in order to do any conveyance of a portion of the lot, the lands really have to come out of registration, and that, as you know, is problematic. It can be done in many cases, but it makes it more difficult and time-consuming. The requirements for the grant of a variance, it requires that the board make a finding that the need for a variance arises from the shape, soil conditions, or topography of the land, which is relatively unusual in that zoning district. This meets that requirement on a classical basis insofar as the land is rear lot of the land is bounded by the brook. It's a very, very unusual shape, and in some portions of the rear line, it's the middle of the brook, which is obviously quite wet and affects the soil conditions. The shape of the property is unusual, so of course that condition is met. Also, that a literal enforcement of the provisions of the ordinance or bylaw would involve substantial hardship, financial or otherwise, to the owner. And because of the unique property lines on this lot, the rigid or literal enforcement of the provisions of the zoning bylaw would mean that that land can never be used to construct any type of home on the entire 15,000 square foot lot. So I believe that we meet that ring on the requirements for the variance. Also, it is necessary that for a finding that desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent or purpose of the ordinance or bylaw. And I think that this is easily met insofar as the proposed house will be approximately 140 feet away from either of the dwellings that have any property ownership on the other side of the brook. Furthermore, the middle property, which is currently owned by the Hartfords, there was put up quite a few years ago hedges which now rise to about 30 feet. So it is relatively invisible from that particular property. This property has been in the Shute family since the 1950s, and thus they have owned the property for approximately 55 years, and they owned the property, the abutting property on Russellwood Road before Mr. Shute died some years ago, and the Russellwood Road property and the house thereon was sold off. I would like to show the board roughly what is being considered as far as the type of home that is going to be built. However, I would like to point out that before any construction can take place, this would have to go before the Conservation Commission. And because of the Wetlands Protection Act and also the Riverways Act, there'll be a number of thresholds that need to be crossed before the construction will take place, particularly as far as what kind of building will occur, how close to the waterway, will there be any do not touch or do not put up any walls requirements, and that this will all have to be addressed before the Conservation Commission, as it really should be done. But before going to the Conservation Commission, we need to go before the Board of Appeals and at least get the variance in order so that some construction can theoretically take place.
Good, thank you for your presentation. You've answered my third question first, and that's the Concom issue.
Yes.
Have you had any informal consultations with the Conservation Commission about this
We are
issue?
preparing the notice of intent at this time, and we plan to have it with the Concom. And usually the first step would be the meeting with them, and then they go out and do a site visit, and we go on from there.
When the DeSalle and Burke folk went out to the site, they delineated the 25-foot wetland buffer
Yes, they
as shown in
did.
this plan.
Yes, they did, and that is shown on your plan. So you have a 25 feet and you have a 50 feet.
And so that's a reasonably accurate line of demarcation.
Yes,
is
it is.
not? So my question is, to what extent, if at all, does the presence of the wetland buffer affect the location of the proposed dwelling on the house, on the lot, and perhaps the size of the dwelling that you anticipate constructing?
Well, number one is, as a residency district, it requires a minimum front of 20 feet from the street to the front of the building. The lot is irregularly shaped insofar as at the very right edge, you have a depth of 168 feet from the Brook Road to the wall of the river. I'm sorry, the brook. Whereas on the left-hand side of the house, proposed house, you only have somewhere around 20 plus 2141, and maybe 35 feet. So that would be the only location in which you could practically build a house. If you go any further to the west, you do not have enough room to build a house between the Brook Road and the Pine Tree Brook.
Do you know the gross building area of the proposed residence?
Pardon me?
What size is the residence? What's the gross building area of the residence shown on this plan? Do you have any idea as to that?
I don't know. I know it's, the entire lot is 15,367 feet, but I'm not sure what what portion of that is land and what portion of that is water.
I guess my concern is if the Conservation Commission imposed additional restrictions.
Yes.
That we're presently unaware of, whether if you had to shrink the size of the residence or the proposed dwelling, whether that makes the proposed development and the proposed acquisition of the lot feasible or economically unfeasible. And I know you can't answer that question, and I'm not posing that question to you, but I guess the question is if we granted the relief that you request, and I understand the legal basis and the factual basis, and the Concom imposed conditions that didn't satisfy the buyer or the proposed developer of the site, and they're probably one and the same, we would have granted a variance to a piece of property that at least these buyers don't want to build on. And I guess that's a... Do you have any response to that? I know it's pretty...
That if the Concom put in restrictions, they could put in restrictions that would make building on the lot impossible.
Yeah. I guess what I'm saying to you in a sense is does it make sense for this board to be awarding variances under this circumstance until you know what position the Concom is going to take? And then once you know their conditions, if you want to go forward with it, then we'd know exactly what project is being proposed.
I think it would be the other way around in this particular case, and the reason...
Tell me why.
And the reason for it would be we need to provide a notice of intent to the Concom, and we would say this is exactly what is being proposed and why it is being proposed. If we propose that without having gone through the Board of Appeals first, we'd be proposing something that is in violation of our zoning and could not be built.
Right, but we'll have to see how this hearing goes and how the evidence
That's right.
goes. And we'll have a better idea as to whether it's reasonably likely that Mr. Downey will get the relief that he's requesting. I guess my question is if we grant a variance, and we certainly can make a variance condition on the applicant being in full conformity with any restrictions or conditions that the Concom imposes, but we can't make the variance, to the best of my knowledge, and my colleagues here can weigh in on it, but I don't think we can make the variance conditional on the Concom granting relief so that a building can be constructed on it, and if they don't, somehow the variance is revoked, because the variance is given running to the land, but.
Well, remember,
that's a question
the
we can
variance
vote
can
on.
only be used for a period of 1 year after the issuance of the variance. So it is not a situation in which the Board of Appeals would grant a variance and then it would hang out there for 15 years and be possibly troublesome to the town or to anyone else. This would require the applicant to go to the Concom and obtain relief on a fairly quick basis in order for it to go forward. If it took a little bit more than a year, then it can be extended for a period of 6 months without difficulty, but variances typically have a very short life, and
Right, but then wouldn't we be coming back here and, if that happened, if the conditions were onerous, this deal falls through, then we really don't know what's ever going to be built there, and we've granted a variance, and somebody comes in with a proposal that if we saw it and we didn't like it, we may not have voted the variance in the first place. I don't know whether we're buying a pig in a poke here, but and I don't mean that in a sarcastic way, but let's proceed and let's see if my colleagues have any questions.
Excellent.
Thank you for answering my questions. Mr. Jeffrey Mullen, please.
I wasn't following the purpose of the 2007 hearing and the 75-foot comment. Could you go through that again? Why were you here in 2007? Or why were the chutes here in 2007?
okay, this land back here, the same person owned both parcels. And the width is less than 75 feet, 62.64.
Yeah.
And that makes it a pre-existing non-conforming lot insofar as it did not have a width of 75 feet or greater. One of the rules in town is if you are going to do any modifications to a boundary line of a pre-existing non-conforming lot, then you can only do it with the permission of the Board of Appeals. That's why we were here at that time. And the board granted it, and the deed was processed so that the people that bought the land on Russellwood Road bought to the middle of the brook as it exists currently, rather than as it existed in 1937.
All right. Is it fair to say that the reason so that was at the time that the chute sold the property on Russellwood?
That's correct.
And they wanted to sell the property on Russellwood so they would have a better chance of developing the property on Brook. Is that right?
Well, the people that bought Russellwood only wanted to buy a house, et cetera, so it was split in two.
Yeah, okay.
It did not make sense for the people in Russellwood to buy a lot where the back of the lot can only be reached by,
Right. What's the 30% of the mean depth of the lot, do you know?
it depends on what you mean by mean depth, because...
I don't know, but that's what the bylaw says, so that's what I want to understand.
Well, 30% of the mean depth at this point would be, it's over 100 feet from Brook Road to the middle of the brook.
Yeah.
So it'd be 30 feet.
Did the cell do that calculation? Do you know?
Pardon me?
Did they do that calculation?
Um,
That's where you got the 30? Is that what was, I'm trying to understand whether or not we need to pay attention to the provided, however, no building need be set back from the rear lot line more than 30% of the mean depth of the lot.
I tried to see if I could fit a house in where the 30% rule would go into effect rather than the 30 feet rule,
So good, that was a good idea.
and it could not be done.
Well, maybe should have had somebody else do it.
I discussed this at length with the building inspector,
All right,
And,
I trust you.
because that would have avoided the necessity of having to come before the Board of Appeals.
Yes. What's the distance between that closest corner and the, it's a concrete wall, right?
Yes.
What's the distance
Well,
between?
it's not a concrete wall.
What's holding
There
the-
are huge stones, each of which probably weigh
The edge of the brook,
some tons. What?
what's the distance between that? The
Between what?
corner of the close corner here and the brook itself. Do you know? Instead of the property line. Or the fence.
The fence is, okay, the fence is about 4 feet from the wall, about 4 feet from the wall. And then on the other side of the wall,
There's some feet.
there's some dirt and land and even some trees.
Yeah.
Because the brook doesn't always fill up
Yeah.
the full distance between the land and between the two walls.
I guess what I'm trying to understand is, for the property at 54 Russellwood, which owns that small triangle on the south side of the brook,
Yep.
registered land, the conveyance of that is unlikely.
The what?
The conveyance of that property to the property owner on Brook Road would be unlikely for the reasons, you would want to avoid a subdivision of registered land, I understand that. But as a practical matter, 54 Russellwood doesn't really enjoy that piece of land. They can't even get to it, right?
No, they can't.
My question is, what's the distance between that and as if the edge of the brook were the property line? How many feet is that?
Approximately 17.
17 more feet?
This yellow line, this yellow here would be approximately 17 feet.
17 more feet.
And
So that would be
17 feet.
27 feet.
What?
27 feet from the edge?
No, 17 feet.
Here's what I'm interested in. What's the distance between this point here and the edge of the brook?
Oh, then that would be 28 feet,
About 28 feet, not 30.
not 30.
Okay. Whose fence is it?
Whose fence
The
is it?
chain link fence?
I don't know. I think it was put up when they did the wall back in 1956,
It's in
57.
pretty good condition, you're saying?
It was 1957. It's not in good condition now.
Is the brook maintained by the town?
I know as being part of the Pine Tree Neighborhood Association, every year we go out and take the debris out of the brook and,
You don't know.
you know, we have,
The answer is, you don't know. All right, fine. And is,
it would be by the town. I know that they attend to it.
okay. So if you're looking at the lot, the house on the immediate right, is that 400 Brook Road?
Yes, it is.
Okay. I don't have any further questions.
Mr. Gray, do you have any questions?
I do not have anything further.
Okay. I don't have any further questions, Mr. Sheffield. Let's see if there's anybody present. Have you finished your presentation?
Yes, I have.
Okay, great. Let me ask, is there anybody present this evening who wishes to speak in support of Mr. Downey's application for variance? So the record indicates there's no such person present. Is there anybody present this evening who has either questions of Mr. Sheffield regarding this application, or who otherwise wishes to speak in opposition to this variance application? Yes, sir. Why don't you come on up?
Yes, my name is Joel Kwong. I live at 400 Brook Road, right next to the proposed building.
Good. Welcome to the Board of Appeals.
Spell your name.
Would you just spell it? Is it K-W-A-N?
Kwong.
O-N-G. K-W-O-N-G. Joel, why don't you grab a seat?
Okay.
So you'll have the microphone and have it right in front of you, and any people in TV land will be able to hear you.
I hate to sound like a jerk, but, you know, I'd love to have a house next to mine, but the problem is that area, the groundwater, the ground gets very wet, especially when there are torrential rainfalls. And my basement gets flooded. My neighbor's basement gets flooded frequently during the rainstorms. And I've tried to mitigate the flooding by, you know, diverting the water away from the house. And if
In which direction away from your house?
all
over.
all over, all around. But still, my backyard ends up getting muddy frequently. Well, actually, all around the house gets muddy during the heavy raining seasons. So if they build a house next to mine, they would have to clear all of the trees and all the vegetation that actually absorbs a lot of the groundwater. And not only that, they will have issues with water in their house because the water table is actually quite high during the rainy season. So they're going to have to divert the water away from their house. And my worry is that there's not enough area, dry land, to divert the water. So flooding is going to, be a worse problem for myself and my neighbors. So that's the main reason why.
Okay, do you have any plans of your house or photographs of your house?
I didn't bring.
I'm not being critical, I just want to know whether you have them.
No, I didn't bring any with me.
Okay, and do you have any photographs of the subject area here where they intend to build the house? Maybe on your cell phone or your iPad or something? Or
No, I don't have any photographs.
want to know the condition of the subject property, how wooded it is, and how...
Pretty heavily wooded, actually. I wouldn't call it woods,
Okay,
but there are a lot of trees.
Yeah, there are a lot of trees and there's a lot of brushes that I feel help take the water out of the ground.
and what type of water diversion system do you have in your house, Mr. Quinn?
I extend the gutters. Basically, I buy PVC and other plastic extensions to extend it like several feet away from my house.
Okay, do you have a sump pump in your basement?
Yes, and during the raining seasons, my sump pump goes nonstop for weeks. So,
Well, thank you for your comments. Why don't you stay right there for 1 second?
okay.
And Mr.
Can we ask
Jeffrey
him a
Mullen.
question?
Of course you can ask.
But
Mr.
it's only wet during the wet season? It's not wet year-round?
Not year-round, only when there are torrential downpours, like
What-
probably once a year. But the first year that I moved into the house, we got a lot of rain, and it happened over a period of a couple of months in the springtime.
What's the condition of the wall that's holding the brook back?
It's rocky. It's not a real wall. I guess it's
Just an aggregate of stone?
yes.
It looked like Quincy granite when I was looking at part of the wall before the meeting.
And there's a fence between your property and the subject property?
Yes.
Is that right?
Yes.
Is that your fence?
I don't know who it belongs to. I have no idea. I maintain it. I clean it.
Mr. Gray, do you have any questions of Mr. Kwan?
Are you concerned at all about the location of the house on the lot with respect to where your house is?
Not as much. I mean, the other house is about the same distance, my other neighbor's house. So I'm not really as concerned about that. It's just more of the, how it would affect me, if I had water in my basement more often.
Okay, have you had an engineer or a hydrologist look at your house? Not necessarily
Yeah.
for this application, but just to determine the cause of the water and whether your system is effective and how you'd be affected by neighborhood development?
I haven't. I haven't hired anyone.
And I'm not suggesting you have to for a Board of Appeals hearing, but it's obviously an issue.
Yes.
Okay, so why don't you stay right there for a second? Mr. Sheffield, do you want to discuss with us whether DeSalle and Burke has considered the hydrology of this site and the effect that it would have on
This area
neighboring
of town
properties?
has had water problems for the last 60 years that I know of. And that is why the Pine Tree Brook was diverted and changed, and that's why there is a watershed up in the Blue Hills now, because this is a major tributary going into the Neponset River just before it reaches the ocean. There is, this feeds Turner's Pond, and it's an interesting situation. But when you get down into Audubon Road, Parkway Crescent, Mar Ave, Lincoln Street, these are all areas that have been underwater when there is substantial rainfall. And it's the history of this section of the town.
Well, I assume that's true, but I thought my question was whether DeSalle and Burke had studied that issue and whether they had perhaps discussed with Mr. Downey or his development partner what type of water mitigation would be required to construct the proposed dwelling that you show on the plans that you've showed us, and then taken the second step and would give evidence as to what effect the construction of a residence of this size would have on a property like Mr. Kwan's property.
Okay?
I mean, that hasn't been investigated, I think.
Right, well, there's two things. Number one is that is in the process of being investigated now, and it will be necessary for the notice of intent that's going to the Concom. The second thing is that the issue that Mr. Kwong brings up is definitely something within the direct purview of the Concom, and they will want to know what the water situation is. And there is also a rule in town that you cannot get rid of your water by putting it on somebody else's property. So we would have to do construction in such a way that would not create a hardship for Mr. Kwong, and that's part of the building requirement.
Right, but you're asking us to grant a variance under these circumstances where we have no evidence on this issue and leave Mr. Kwan to the discretion of the Concom.
No,
I don't know whether
I'm
that's...
saying Mr. Kwong is protected in other areas of the town. What this does is it lifts the structure or the requirement that we have 30 feet rear lot line, and that's the only thing it does. Granting of a variance, the applicant still has to comply with all the other rules, regulations, building plans, and everything else.
But the standards for you to get a variance are much stricter than they are to get relief from the Conservation Commission. So if the Concom proposes some type of mitigation system that Mr. Kwan believes won't work, then his remedy is to go and hire a fancy lawyer and litigate this at the cost of thousands of dollars in the Superior Court, when he really doesn't have to do that now if we can get an assurance for him from a competent engineer. And I know DeSalle and Burke not only are competent, they're skilled in this particular area, because they've testified in this area before us on other cases before we exercise our discretion. But I don't know how my colleagues would weigh in on that. But we'll deal with that. Mr. Kwan, thank you for coming. And
Thank you.
you're not a bad guy for appearing, believe me. Is there anybody else who'd like to appear? Yes, sir. Come on up here and take a seat. Tell us your name and address, sir.
My name is Peter Walsh. I live at 374 Brook Road, Milton, Mass.
I'm sorry, would you tell me where you live? I missed it.
374 Brook Road, Milton, Mass.
374. Thank you. Peter Walsh. Welcome to the Board of Appeals.
Hi. The Schutz property, they had a backyard, and then on the other side of the backyard was a wall, and then there was swampland. So they didn't have any plans of building a house down on the swamp. That's swampland. As to the wall on the other side of the brook, it consists of big rocks and then a slab of cement about 12 to 14 inches thick, and then 4 feet with grass growing, and then a fence. And I also oppose a house being built there. That was swampland, and they gave Mr. Shute the land on the other side of the brook because they took away the swampland. I used to go down in the swamp there. Was all kinds of skunk cabbages and everything down there.
So what is your position on this particular application for variance?
I oppose it.
Okay.
I also spoke to the gentleman there and his wife opposed it too. The houses would be too close
Who's
together.
the gentleman? Is Mr. Kwan, do you mean? Yes. Okay.
But he left that out. Maybe he forgot that.
Or maybe he was
But
nervous
his
appearing
wife
before the
proposes
board.
it. She doesn't want a house right beside, you know. But that was swampland, and they gave the Schutz the land on the other side of the brook to make up for taking away the swampland. But they wasn't gonna build no house on the swamp. And I think what the town should do is take the land and probably put in a few chairs down there and just leave it for greenery and pine trees and stuff like that.
Well, I laugh because most of the members of the board here do have some affiliation with eminent domain, and it's the exercise of eminent domain in the Commonwealth. I'm not laughing at your particular proposal. Would love to see more takings, but they're not making them these days for public purposes and not necessarily in this area, obviously. Let me see if my colleagues have any questions. Mr. Jeffrey Mullen, do you have any questions of Mr. Walsh?
Where's 374?
I live right on the other side of the brook,
So you're the other about it.
right beside the brook.
You're the house with the boat in the yard?
What?
Did you have a boat in your yard?
Yes, I did. I got rid of the boat,
You were at the boat?
yes.
All right. I don't have any questions.
Okay, Mr. Gray.
Can you describe for me the sort of topography between your house and where this lot is? Is it open field? Is it heavily wooded? How does it
Well, I
look?
face Brook Road, and on the other side of the brook is that lot that you're talking about, and then on the other side of that is the gentleman's house.
Correct. And what type of vegetation, if any, is between your house and where this proposed house is going to be?
Grew some pine trees down there, you know, just to grow things.
Do the pine trees screen at all the view between your lot and where this proposed house is going to be? Or do you have a clear shot when you're standing at the side of your house looking towards this area?
The pine trees help to make the place look good. But I can see their place, no problem at all.
And between your house and this proposed house is the water, is that correct?
Yes.
It's the what?
The water, the brook itself, like a
Yeah,
moat
yeah,
between the
yeah,
two.
yeah.
I also own some of the land down there in the brook.
So that your lot line maybe this is a question more from Mr. Sheffield, I'm not sure. Is he a direct abutter then?
Yes, he is.
Yes? Okay.
Well, yes, he is.
With the brook in the middle somehow?
Yeah, he's, as if, the brook is owned by, not owned by the town. He's a direct abutter.
Okay. Thank you very much.
Mr. Walsh, would you just tell us, do you experience any water conditions in your basement?
No, I have no problem since they built the new bridge.
Good, thank you for coming tonight, we appreciate it.
Thank you.
Let me ask, is there anybody else present this evening who has a question of Mr. Sheffield or wishes to speak? Yes, sir, come on up and tell us your name and address and...
Absolutely. My name is Corey Sprague. I reside currently at 54 Russellwood. However, I am not the current property owner. I'm here more as eyes and ears for the Hartfords as well as the Erskines, to be hopefully the owner in a relatively short period of time on 54 Russellwood.
Okay.
In speaking with those parties, nobody begrudges either party from selling and or buying that property and doing what they need to do with it. I know that in talking with both parties and with myself, as for future reference, I would like to see some sort of conservationally, ecologically smart privacy fence and or something put up that the Conservation Committee would deem a nice private kind of separation that goes along the lot lines, not necessarily into the brook, of course, but where you actually have the metal fence. Once that lot is cleared, there's going to be direct runoff just due to the grade right into the brook. Not only that, but it's going to open up, those backyards are going to be susceptible to just seeing clear out into Brook Road at that stage and the middle school. Right now in season, the vegetation gets thick enough and there's enough vegetation there that it feels like you have you have a wooded backyard straight through. You know the road's there, you hear the road, but you don't see the road. And that makes a big difference when you're surrounded on three sides of roof lines to have that kind of a long view, what we'd call a long view. But as far as I know, no parties are opposed. If there were some sort of variance given, that some sort of privacy was set up along the back lines, just so that those houses on Russellwood would have that. And I've been asked by the parties what they can do to, moving forward, how they could submit such a request, and sign off and give their blessing as long as there was some sort of assurance that that was going to take place.
Great. Mr. Gray, do you have any questions of Mr. Sprague?
So what exactly is your connection to this, to 54 Russellwood? I'm not.
He's a potential buyer,
Potential
are you not?
buyer?
I'm the current tenant for the past year and a half, and yes, and in
Okay, so you're
in conversations of purchasing the property.
a tenant at 54 Russellwood.
Correct.
But you have not signed a purchase and sale agreement to buy the
Correct,
property.
that's why I said I have no say here.
And you have no
I'm just-
option on the
I'm
property,
just,
is that
yes,
correct?
I'm just conveying their voice.
Okay.
And you're speaking for the Erskines, and what was the other party?
The Hartfords.
Hartfords, of course.
That's
Thank you.
54 and 50 Russellwood.
Sure.
I don't think I have another question at this time.
Okay, Mr. Jeffrey Mullen has no questions. Thank you, Mr. Sprague, we
Thank you very
appreciate your
much.
coming. Is there anybody else present here who wishes to speak with respect to this application? And there's no such person present, so, Mr. Sheffield, do you have anything else to add before the board considers the
Yes, I
application?
do. Number one is I'd like to present a map that might be helpful to see the properties that are the neighborhood, if you will. And
And this shows the current location of the brook.
this goes,
Is
the
it
current location.
current location,
That
yes.
is correct. That is correct. And the question before the board tonight is, should we require the 30 feet rear setback in this particular situation, or should it be waived? And my suggestion would be that it should be waived because of the unusual topography, because the land that is within 30 feet is on the opposite side of the brook and is absolutely inaccessible to the owners of the property without going down the wall and swimming across. That it is a minimal type of variance insofar as the proposed location of the house is at least 140 feet from the home that owns the land that would be close to the structure. That the suggestion that this land was swapped for other land, I don't understand at all, because this land was purchased from Mary Taylor back in the 1950s. And Mary Taylor didn't own anything on the other side of the brook.
I understand what you're saying. I'm not sure that's an enormous consideration for the board. but,
Right.
So why don't you continue with you?
But I believe that this would be the best use for the property. It's a reasonable use for the property. I think that the people next door are concerned that nothing be built that worsen their water situation. I think that we have stipulations in town that you cannot build a home that is going to flood the home next door, and that's already a
Or
control in
adversely,
existence.
maybe adversely
adversely
affected and not necessarily flooded out.
Okay. You cannot adversely affect the, another existing home. And so that's not really an issue here. And,
Well, except if you're Mr. Kwong. He's
What?
except, unless you're Mr. Kwong, and then he's gonna sit there
Well,
and
unless you're
hope
Mr.
that his basement doesn't fill up.
unless you're Mr. Kwong, where you, the natural reaction would be, you know, I have my house, I don't think any other houses should be allowed to be built because something bad might happen. Well, let's
No, I
prevent
think all
something
he's
bad
looking
from
for
happening.
is an assurance to address an issue that the applicant hasn't addressed and doesn't seem to want to address before this board, but I don't want to get into an argument.
Yeah, I don't think he can address it before he gets to the Concom, and I think the Concom is the proper area to address it. I told Mr. Sprague's wife that, in my opinion, the issuance of what kind of a privacy fence could be constructed within the, near the wetland, et cetera, is really more of a question for the Concom. Neither he nor she were notified by the town of this hearing because they're tenants rather than owners. I agreed to notify them of any future hearings so that they would be cognizant of what is going on and why it's going on.
Great, thank you very much, it's very gracious.
And I think that the applicant has met the test of the, for the grant of a variance, and I think that the grant of a variance would be appropriate and properly issued in this particular matter.
Great, thank you for your presentation, Mr. Sheffield. I mean, did you have a question, Nick, of Mr. Sheffield? Okay.
Not at all, thank you.
So let's have the board members discuss this application, and we'll see what we're going to be doing with it. Mr. Jeffrey Mullen, please.
So I think in the scheme of the variance, specific variance that's been requested, the 30-foot setback, I'm not troubled by that, given the things that this board has dealt with, particularly given the irregular property line and the impact on the direct abutter. However, I think I am concerned about potential adverse effect on the adjacent properties that I think is unresolved at the hearing. To the points that you were making, Mr. Chairman, the privacy screen requested by the abutters on, or the representatives of the abutters, or the tenants of the abutters, or the prospective purchaser of the abutting property, but in any event, it was raised as an issue. Seems to me to be a reasonable request, but I agree with Attorney Sheffield that it's a troubling issue for the Board of Appeal because we don't know whether or not the Conservation Commission would permit that to be done, and where would it grant relief subject to the privacy screen, and the privacy screen wasn't permitted to be constructed in the buffer zone. I don't know where that would exactly leave us. Perhaps more importantly, but equally importantly, Mr. Kwong's got some existing water issues that I do think it's reasonable to think might be exacerbated by development on the adjacent property. And while I think that also can be addressed, my overall concern is that we're not well equipped to address those issues without the advice of the Conservation Commission. And I wonder if it might not be better, I mean, with that as backdrop, so I don't find the request to be outrageous in the scheme of development proposals in the town, but I think there are too many unanswered questions. And both from the board per se, the types of questions we would ordinarily have, and the testimony that we've heard, that I'd really like to hear from the Conservation Commission on the particulars of the impact on the adjacent properties and what the development potential are. So I don't know if it's appropriate for me to suggest, but I might suggest a postponement of the hearing, or a suspension of the hearing, and then a reconvening after the Concom has spoken. Because at the end of the day, what I'm mindful of is, I don't want the Conservation Commission to be to be hearing this in any way, saying that the Board of Appeal is forcing them to, that it's now the house is going to be there. So I think that may be a factor as well. So that's my view, and that's a suggestion made to my colleagues as maybe a way to address it.
Okay, Mr. Gray, please.
Thank you. With respect to the specific variance that you're looking for, which is relief from the 30-foot setback from the rear lot line, given the unusual nature of this lot, the orphaned nature of this tiny triangular piece of land, which although a part of the lot on the other side of the brook is not accessible absent waders and getting poison ivy probably, it would seem from granting relief as to that 30-foot setback requirement would make sense if that were the only issue. I too am concerned, given the proximity to the brook and mindful of not wanting to cause damage, water damage to some other property. I am concerned that digging a foundation in that area might somehow obstruct the groundwater. I think I would feel more comfortable if, for example, we had heard from the engineers as to how the proposed dwelling might affect the waterland. If I'm making it, as I say, if I'm making a decision purely on the basis of the lot lines, I'm inclined to see the justification for variance, but I am concerned about not doing substantial damage to other property in the neighborhood. So I think Mr. Mullen's suggestion is well taken, and that's pretty much what I have to say, I think, about it.
Okay, well, look, I agree with my colleagues. I intend no criticism of Mr. Sheffield or the potential buyer here for not bringing in DeSalle and Burke and doing a huge discussion of the house, which you haven't been allowed to build, and how you'd mitigate water conditions, not only for the proposed dwelling, but for the neighbors. That's kind of an expensive proposition, and it may be premature before the Board of Appeals. But on the other hand, I think this whole application is premature. We're not experts in conservation, in wetlands, in the travel of water, and in the geology of this particular area. At least I'm not. And to me, it seems like it's entirely appropriate that while you can make very powerful legal arguments that you do meet the conditions that the board could award a variance, as you know well, Mr. Sheffield, nobody's legally entitled to a variance, even if you can prove all of the statutory elements. The board, in its discretion, can deny a variance if they think that other people would be adversely affected. And here, I think that's a distinct possibility and maybe a probability. And so I tend to think that with proper conditions in the Conservation Commission, with proper study of maybe Mr. Kwan's property and opinion evidence from DeSalle and Burke as to whether this proposed development would work or not work, would be meaningful and powerful evidence, at least for me, as to whether to exercise my discretion to vote in favor of this variance. And you may find that the Conservation Commission and DeSalle and Burke may be able to put their heads together, and then we'll know exactly what's going to be built here. And Mr. Kwan will know exactly what's going to be built, and we can tie it into the specifics and hopefully have the matter discussed in an intelligent sense. I think for the board to allow a variance under these circumstances, there are too many items open to conjecture. I think it would be improvident for the board to do it, and I think it would not be in the best interest of the neighbors in the town for the board to vote on the application for this at this particular time. And I think what we should do, if you want to do it, Mr. Sheffield, is continue this hearing for a period of time. I don't think you should be forced to reapply and come back and spend another hour and a half with us. But come back to us at an appropriate time with an order of conditions from the Conservation Commission, maybe findings on the DeSalle and Burke water mitigation plans, and then I think we can address the issues which are most of concern to the board. And I think you can certainly indicate to the Conservation Commission that in terms of your property being adversely affected by physical conditions and all of that. The board fully understands that, but we think that we really need to hear from the commission before we vote on this application.
Excellent. I would suggest that it will probably take a minimum of 60 days for the Conservation Commission to review the notice of intent. I would request that maybe somewhere around 75 days. I think it's important that we have a fixed date.
I think so, too.
And if we're not ready at that time, we could,
Absolutely.
adjust it.
Absolutely.
So I would say somewhere in about 75 days, which would be approximately July 15th or something.
Okay, Mary, what do we have? We don't have anything out that far. No. Do you have a calendar? Okay, I do.
I do.
The phone.
Get you.
Electronic.
Well, I don't go out that far. I mean, that's,
Would you excuse me for 1 second?
of course. So we're going to suspend this hearing just for 2 minutes and allow Mr. Sheffield to speak presumably with his clients, but we don't know who he is. Things are magic if you can get them to work.
Because it's not on flat surface?
No, I'm not using my stylus. 16, 17, 23, 24. Make any difference? Do you have any, Nick, how about you?
I'm not going away that month.
How about you, Mary?
Hey,
I go away August 1st.
how you doing?
Okay.
Brian? Time no see. How you been? I think I told you. We'll see you then. Used to be more jock than I ever did. Back in the day. Bring them in the guns.
And Mary, would you prepare a stipulation for Mr. Sheffield to sign? Mr. Sheffield, two things. Number one, I assume on behalf of your client, you'll sign the usual stipulation continuing the time.
I already
for-
have, sir.
You have, that's wonderful.
Oh, yeah, that's in
It is in there, okay. Well, it's, we're looking at Tuesday, the 16th of July, or the 23rd of July, if
I
that's...
think that by the 16th, hopefully, the Concom will have already been able to address this issue, and hopefully we'll be able to go forward.
That's great, and if the Conservation Commission has done that, would you be sure to file a copy of the order of conditions and perhaps any DeSalle and Burke plans or analysis of the hydrology and that type of thing with us, perhaps
I definitely,
a week in advance, so we can review it and be prepared for the hearing?
definitely,
And then we won't have to continue it at another time.
exactly.
Great, well, thank you for your courtesy.
Thank you very much. and,
Well-
I-
16.
We're going to continue this until July 16th at 7:30. I'll say in this room, but obviously check the bulletin board because we may be stuck downstairs.
Very good.
Okay,
I
thank
thank
you.
you very much, and I thank the members of the committee.
Thanks.
I'm gonna hustle up, all right? See you, John.
Nikki, wait until... Thanks.
Thank you.
I didn't see it.
I didn't realize it was the extension.
Oh, okay. Oh, wait. There it is, okay.
And I have another one, in case this one doesn't go.
Okay,
I don't know, lady.
that's okay. Brian.
All right.
Nice to see you. Mr. Francis O'Brien. What's that? I'm fine.
I find myself making these decisions shorter and shorter.
No, you're up.
You're up. You're the only hearing. Go ahead. Nifty little folder, isn't it? I'm supposed to do something here.
I believe we are okay. This is new, copies of what you already sent.
I sent it to you, but you wanted to know whether I was bringing copies of it.
Oh, if anybody here.
Oh, yeah, well, then we'll just put them up on, yeah, absolutely, put them right here. We're ready to start anytime because we're actually not starting with the PowerPoint, so whenever you're ready.
Yes, I am.
Right.
Yes.
Mary? Ladies and gentlemen, we're going to call to order our second hearing of the evening. This is a continued hearing. It's on the application of Seasons Hospice Foundation dated March 4th, 2013, seeking a special permit in order to to purchase and use the premises at 597 Randolph Avenue as a hospice facility. The premises are in a residential C district. The board held an extensive hearing on this application on April 2nd, 2013, and here we are again. At the end of the last hearing, we had a series of questions for the applicant relating to terms and conditions of the lease and the relationship between the nonprofit proposed owner of the property and the operator of the property, and then dealing with very particular issues relating to noise of the air conditioning and other facilities, and the dumpster and traffic issues and the like. And so we asked Mrs. McGetrick to kindly send us responses to those questions in advance of the hearing, so that the board and the public, if they wanted to, would have the opportunity to come to the Board of Appeals office and and see the responses. So on April 18th, 2013, Mrs. McGettrick filed the package as she promised to do, and for that, we thank you.
You're welcome.
Just for the sake of the audience here, let me just make some basic introductions. My name is John Leonard. I'm chairman of the Board of Appeals. With me, to my immediate left is board member Brian Hurley, and to my immediate right is board member Frank O'Brien. We recited the rules of the board at the first hearing. I'm not going to do that again. So I think perhaps Mrs. McGettrick, what would be helpful to the members of the board and to anybody who's in the audience here is perhaps you could take your submittal of April 18th, which, and you've submitted many different rather distinct packages relating to the issues, and without going into them in enormous depth, but if you could summarize what your position is on each of these, then we can see if the board members have any questions as we go through these. I know Mr. Hurley was particularly concerned with the relationship between the proposed owner and the operator, and Mr. O'Brien was more concerned with operational issues. So perhaps we can handle those, and then we can see where we are.
Okay.
So welcome back to the Board of Appeals.
Thank you very much. We're happy to be here. And again, we have Gregory Grabowski here, who is the director of Seasons Hospice Foundation, and Mark Dibbs from Condyne Associates, so that's the engineering firm, and also Kathy Bliss, who's the director of Seasons Hospice and Palliative Care of Massachusetts, LLC, the proposed operator of the facility. I guess I'd like to start out, and we will try to summarize. I know that it's fairly detailed, the material we've given you. One thing I didn't actually put in my materials, but I wanted to address right at the beginning was the question that Mr. Hurley brought up last time. He had mentioned or had identified the case of Regis College versus the town of Weston as one that I should be thinking about, or we should be thinking about in terms of what the issue is before us in this case. And this case is not actually finally, it hasn't been completed. It was heard by the Massachusetts Supreme Court on a summary judgment motion, and now the case has been returned to land court, and they're having further hearings on issues of credibility and the weight of the evidence on whether the principal use of the proposed residential facility would be educational. That case is about the Dover Amendment. That's an exception to use regulations under zoning for educational and religious purposes. And it was a proposal for a very large residential, I guess over 55 or over 65 facility. And the purpose as presented by Regis College was that it was going to be an educational purpose, but it was a residential facility. So we don't know what the outcome is in terms of the final decision, but the reason that case is significant in terms of what we're doing here is that it's really about, or one of the things that the court talked about was how do you decide what a use is for the purposes of zoning? So if you say a use has to be educational, or in this case it has to be charitable or nonprofit, what do you look at? And in general terms, what the Supreme Judicial Court said was that you have to look at whether the use is substantial. And that was there are a couple of cases that they cite within their decision, their Regis College decision. But the principal use, there can be a subsidiary use, but the principal use has to control what's going on at the site. And you have to look at the principal use of they call it in some of these cases, the establishment in its totality. So that's what we believe we should be doing here. And that's why we gave you all these extensive materials, first of all, about Seasons Hospice Foundation, because we want you to understand exactly what the foundation does and how that relates both directly and indirectly to what a hospice would be doing at this facility. But so we will summarize, some of the high points of what the Seasons Hospice Foundation is all about. And then we've also provided you with cases about charitable use and what charitable use is and what are some of the definitions Massachusetts cases have provided for charitable use and what some of the different possible characteristics of a charitable use might be. And what we are intending to show you is that this hospice foundation clearly is a public charity, but that the hospice use itself will be a charitable use. And so the combination of the foundation and the hospice use in its charitable characteristics will be a substantial charitable use and will meet the requirements of our bylaw. In addition, we also were requested and have provided specific characteristics or conditions that we feel the board could apply to this permit. And we would suggest that what the Seasons Hospice Foundation would agree to do would be to say in any lease or operating agreement or contract that it has with an operator, that all of the conditions in the special permit would have to be observed by the operator of the hospice. So those conditions would then become part of the contractual relationship with the operator. And we'll describe those specifically as we go along, and if you have questions, of course, we'll answer questions. So what I'd like to do now, if this suits you, is we have the PowerPoint that we showed you. We'll sort of click through the slides, because I don't know if everybody here has seen them, but we'll summarize. And I think we're going to kind of share the responsibility for summarizing. So I'd like to ask Greg Grabowski to start out. And then we're going to go from that into the engineering questions that you asked, ask the questions about deliveries and trash disposal, and I'm going to let Mark Dibbs summarize the engineering aspects, since he's much better at doing that, certainly, than I am.
I'll just ask you a question.
Sure.
I want to restate what I was trying to state at the last hearing so you understand. And maybe, at least for my purposes, it will shortcut this hearing a little bit.
Okay.
I have no doubt in my mind that the parent owner foundation is a charitable entity. You do not have to persuade me of that. I have no doubt in my mind that either because they want to or they'll be required to, that the tenant operator will have a charitable component to what they do.
Mm-hmm.
In my view, and tell me if I'm wrong, that will not be the predominant thing that they do. It'll be an aspect of what they do. Would you agree with that?
It's a very substantial aspect of what they do.
How do you
but
define substantial?
because,
In
well, I
terms of
think that's what
economics?
we,
You define
no,
it. You define
well,
it for me.
partly, and I think we need to explain that to you in a descriptive way. There's part of the care that a hospice provides that's what we call the Medicaid benefit. That's, it's hospital care. It can be provided in a nonprofit way, or it can be provided in a for-profit way. It's highly regulated by the Massachusetts Department of Public Health. So it's medical care that's provided in a certain way because those are the rules and regulations. And it's paid for, hospice care, as it turns out, is paid for by the sorts of resources that most people have available, which means private insurance, Medicaid, Medicare, and then there's a proportion of hospice care patients, we talked about this last time, maybe 10%, but it could be larger if the medical care changes, who don't have any way of paying for that care. At this hospice, those patients will be paid for with charity care. Seasons Hospice Foundation of Massachusetts provides charity care within its own operation. But what we are proposing here is that Seasons Hospice Foundation will backstop that charity care if it's not sufficiently available from the operator. And so patients who cannot pay for their care will be taken care of at this facility. So we feel that this facility will have a more substantial, that's just one aspect of it, but that is something that differentiates this facility from other hospice facilities, whether they're nonprofits or for-profits. Another aspect of the care that's unique is that hospice care, what we call the Medicaid benefit, that's certain aspects of care. But then there's additional care that's provided at this, will be provided at this hospice. And it's therapeutic care, it's counseling, it's special services for families, it's special meeting requests of families. We were just talking about this before the meeting tonight. For example, there's no hospice that provides a funeral benefit that helps families pay for funerals if they can't pay for them. But Seasons Hospice Foundation does that and will do that at this facility. So the additional care beyond the Medicaid benefit is charitable care. The care for patients who cannot pay for their care is charitable care. And there's many unique and specific things that Seasons Hospice Foundation does in addition, in particular cases. And we can give you lots of examples, but depending on how much time you want to spend here, we'll probably just give you a couple of examples of that, will be in addition to what I'm already describing. So sort of routine charity care would be the supplementary services and the counseling and the therapy that isn't provided as part of a Medicaid benefit, and the care for patients who cannot pay for their own care. And then in addition to that, there's specific types of unique provisions that are made when a family requests it. And they're really, it can be anything from, you know, a patient who wants a McDonald's meals and ice cream every day, which is not something normally that any hospital is going to provide. They might not even think it was good from a medical standpoint. But in a particular case, Seasons Hospice Foundation made it possible for that to happen, and it was very meaningful in that case for the family.
Can I ask
Yeah,
this question? And I don't,
so what's the answer? How substantial is the charitable aspect of the care provided within the actual day-to-day hospice operation?
why does the charitable aspect of what Seasons intends to do here, why does it everything have to be monetized? You know, whether people can't afford to make the payment or not, whether wealthy people are there, shouldn't the test of whether your services and even the operating company services are charitable in nature, even though they may make a profit, which may be a frightening word these days, why isn't the nature of the services they perform really the predominant test?
Well,
I mean, that's exactly what you're saying.
I mean, you
here.
can charge a fee and be a charity and be providing charity care. The other characteristics I just described are the fact that the care is provided at a reasonable cost. Everybody, hospice services themselves, but particularly these hospice services, are not available in this immediate Boston area. So this is a need that would be fulfilling, particularly for Milton residents, but also for people around this area. That's another characteristic of charitable care. It isn't strictly on the basis of free. In fact, it isn't on the basis of whether it's free or not, because everything, as you just pointed out, does have to be paid for one way or another.
By somebody, whether
By
by
someone.
the foundation or by private people or by the public in some way, if there has to be a public.
I let Gregory step in here for a minute, because I'm saying all the things he was supposed to talk
The
about.
reason why the foundation wants to be owner, and I'm going to oversimplify this a little bit, but when you have healthcare, there's the clinical part of it, and then you always say to yourself, I wish I had a more in-depth experience. I wish there were all these extra components that could be part of healthcare, the care, the compassion part. And don't get me wrong, that's what hospice has been built on. But the foundation wants to take it to another level. And so while the care is intricately important, one of the things we could walk you through, and I actually have examples, it is to take it to the next level. And to be honest with you, that's why the foundation wants to be owner and wants to lead. We don't want to say that the care is secondary and the foundation is number one. We do see it as blended, but we see a different experience here that we want to show people that end of life can be different. It doesn't necessarily have to be just about the care. It can be very, very, very profound. And I would say, what are the chances of the foundation touching every single patient that walks in there? It's very good. Volunteerism, clinical special things that we're going to do, those all are going to be intricately a part of this facility. And if you want, I can walk you through some examples, and maybe that will help, flush it out a little bit for you, if that helps.
Well, let me see, Mr. Hurley, do you have any questions of Mr.
I don't
Grabowski?
need you to do that.
Okay.
I'm going to say this once, and then I'm going to move on to you can move on to something else. You will never convince me that the predominant use is a charitable use. You will convince me that it's significant, a big, an important, but not predominant. If this was a 48 Section 3 case, I would say you lose, because it has to be predominant, and it's not predominant. You'll never convince me of that. But you don't have to convince me of that. I'm willing to accept the premise that for the purposes of interpreting our zoning bylaw, that it doesn't have to be predominant. I've come to that cathartic moment over the last few days. And so you don't have to persuade me that it's a lot of charitable or it's a good portion. I'm convinced on that, and I've gotten past the legal issues. So I would rather see you focus on the issues that Frank was interested in, which is the typical special permit issues. You persuaded me somewhat reluctantly that we have authority to grant a special permit here. So now the question is should we? And so I think we ought to focus on those issues, and don't trouble yourselves with
We're
trying to
happy to do
persuade me
that.
that you have a charitable component.
really good stories
I buy
for
it. I know.
That's okay.
I'm sure you do. You can tell me some other time.
No problem. No problem.
I do want to just add, my own understanding of this whole operation has evolved, so I understand why you've been struggling with it. And of course, I'm an advocate for the project, so I want to convince you at this point. But I've had to, my understanding has had to evolve. I've come to understand what the foundation is all about. It will be it will be an important part of this facility. It won't just be an owner who's in Illinois somewhere. I mean, there will be an office at the facility. There will be a staff person. So, but thank you very much for saying that, Mr. Hurley, because, there is a lot we could say, but I don't want to belabor it if you feel comfortable with it at this point. I would like to then move on for the time being to the specific questions that were raised about operations. And these are some of the issues that come up when you try to put a different building on a site that has been there in the past. I think, first of all, let's see. I gave myself the responsibility of writing a memo about trash disposal and deliveries. But I did that after discussing this issue with Kathy Bliss, because her job has been working with hospice facilities, developing hospice facilities. And she did tell us when we started working on this that oftentimes the details of things like this, trash delivery, trash removal, trash facility locations and deliveries and so forth, that gets worked out as the building is being developed, because there can be small nuances that aren't apparent. But we did work on it, and particularly, I'm going to address trash first, because I wrote you a memo, and then I've given you a supplementary memo, because what I did was I sent that memo again to the DPW director, the health director, I sent it to the building commissioner, and I sent it to the police department. And I didn't get any response back from the police department, which may or may not mean that they didn't have any problems, but we will be continuing to discuss
I think that they might have
traffic
been
with them.
otherwise
They've been rather busy lately, as you all know. I did get a response back, though, from everybody else, and Mr. Blanchard was particularly helpful, because he explained to me that the key issues with trash storage and disposal are, in addition to whether it's located near neighbors, because there's the problem of there can be noise when it's being picked up, and it sometimes doesn't look too good, so we need to be paying attention to that. And one side of this facility is facing Randolph Ave. The next edge is on a residential zone, although the use is, right now, is a bit mixed, but it's a residential zone. And so we need to be concerned about the issues of security of the container, whether the container is hidden, is inside another shed or something like that, security of the enclosure around the container, whether the top is locked or kept closed, whether the container is emptied as soon as it's filled, because if it isn't, then you can have problems of smell and trash beginning to, be strewn about the ground. So any conditions, for example, that accompany a permit like this should at a minimum talk about the container location, that it's kept secure, that it's emptied as soon as it's full, that there's an emergency number available at the facility so that out-of-schedule pickups can be arranged as soon as they're required. And I guess one of the things that maybe, I don't know if it's unique to Milton, but our health director said the problem in Milton is that people dump their trash in your containers, and that this does happen sometimes across the street at the Tedeschi's facility. So he said, you must ensure that the enclosure is secure, that the container is kept locked, or you're going to have people dumping trash there at night, in the middle of the night, when they think no one's going to notice. So he asked that there be some kind of conditions set to make sure that those things would all happen. Now, there is another type of trash issue here because it's a medical facility, and that's medical waste. And according to the health director, medical waste is highly regulated by the Department of Public Health. It will be separately stored, separately taken away, and there are all kinds of regulations governing how that's done. So all you would really need to put into a permit is that those regulations would be adhered to, or that they would be a condition of the permit, that you would be complying with them. The second issue, I'm going to do deliveries, and then if you have questions, of course, I'll be happy to discuss. On deliveries, it was more of a general question. It's really a traffic issue more than anything else, because the way this facility is designed now, originally it was designed with a separate entrance for trash pickup and for deliveries, and it was going to be on Reedsdale Road. The first time we met with the directors of the departments in the town, they all said, you don't want to do that, because the traffic will be very difficult backing out onto Reedsdale Road, and you don't want to have that near neighbors. There are neighbors close on that edge. So the suggestion was that all of that be located to the left of the main entrance on Randolph Ave. And that's where it is now, and that's where it was in the site plan that we showed you 2 weeks ago. The other thing that you can do with deliveries is that you can require that they be made during off-peak hours. It's more of a practical requirement than anything else, because there's heavy commuter traffic at this site. And I put some hours in here as a suggestion, which were 10 a.m. to 4 p.m., 6 p.m. to 10 p.m., but I feel that if a condition were to be written like that, that you would have to have, you should have a town official who could review those conditions and be asked to approve changes. And it's basically a traffic issue, and whether you're interfering with traffic unduly. So my suggestion would be that it be the police department and the police department's traffic officer who would be able to, any condition would allow changes to be made only with approval of the police department.
But here we have the police department wouldn't even respond to you.
However, I mean, if they think, I mean, it could certainly, I suppose it could just directly be the building commissioner who would then refer it to the police department, and I don't see anything wrong. I mean, I certainly don't think we would object to that if you think that's better.
And that's a little closer to home
Yes.
in the police department.
Any of these conditions that relate to operation of the facility could be first threshold building commissioner, and then he would have to refer it for a recommendation to the department, I think, if you preferred. I don't know how you would prefer doing that, but it would make some sense to do that.
One of the things we usually do when we're writing a decision is we like to make it in substantial compliance with the plans on file.
Mm-hmm.
So going back to the location of the dumpster,
Yep.
stuff happens, I know, in construction, and so things change.
Mm-hmm.
I think that should the board decide to grant the special permit, that the special permit would have a condition that that stuff like that be placed in substantial conformance with the plan, but also that presupposes that the building commissioner has discretion to approve deviations from that for good cause. Would you say that's usually been our practice, Mr.
Well,
Chairman?
I think it is, and I think the concern is when you delegate it out to other town boards, the town agencies, the town officials who never have any dealings with us, sometimes it's not as responsive as we'd like. On the other hand, Joe Prondak knows more about traffic conditions and site planning than we ever will. So for us to presume to dictate to anybody on those issues, I feel uncomfortable. But we have many times have a working relationship with Mr. Prondak, and if he somehow feels that the change is so radical or extreme, or that warrants actual Board of Appeals involvement, then he involves us. Otherwise, he's our first line of defense. He interprets our zoning bylaw in the first instance, and we support him whenever we can. He's a very fair and an honorable guy, and I feel very comfortable imposing that additional duty on Mr. Prondak, and I think he'd do a good job at it, as he has in the past.
I'd join my chairman in that. I don't like this division of authority amongst Tom, Dick, and Harry. I'd rather have it
I
with
think it's a
Joe.
very good idea. By the way, I did show him all of these provisions, not to say that they were the final word or anything, but just to get comments. So, and he was the first person I went to.
I'm glad
So
to
I
hear
believe
that.
that you're correct.
He may be mad at us, depending on what we do tonight, but at least we'll be in good hands, and that's the important thing.
So, I mean, that's not a very detailed discussion of a delivery condition. I wasn't sure whether the board had other concerns that they wanted to raise or that we could try to answer.
It's detailed enough. I mean, I don't want to handcuff the facility, but on the other hand, I want to be mindful of the neighborhood and make sure that the deliveries are at normal and regular hours, that the neighborhood is protected from the deleterious effects of trash not being handled properly. I know as a healthcare facility, you will have to deal with the medical waste and other biological disposal issues appropriately. So I'm not uncomfortable with the way that's been laid out in this, particularly with the understanding that it would be the building commissioner and not other town officials that would be the first line of defense.
Mr. Hurley, do you want to weigh in on the...
Yep, that's fine.
Okay. Then why don't you continue with your presentation, Mrs. McGinn?
So the next topic, the next two topics were sound emissions, sound suppression, and then lighting plan. And we have given you some information on that, but I think Mark Dibb is going to try to address that.
Can you speak in English?
I'm going to try.
That's what we've asked. I've asked her to
This is
do that.
gobbledygook.
Okay.
Exactly.
It's very engineering, but you're talking with a bunch of lawyers here, so.
Just a quick review. Regarding the noise, I'm going to start with the noise first. A pretty significant design feature of the building is that flat roof area in the middle of the back of the building. On the site plan, I've even identified, there's some dashed, I'll bring this over here, some dashed rectangles. These signify the units themselves. We've also provided renderings of those units. I think you have those, so we've provided that visual graphics to go along with this. And what we did was take the manufacturer specifications for the noise that the two large units put off, and they do have some very detailed noise information in the specifications. And those units using the 50-foot sound measurements is typically a rule of thumb that they use. And they put off a decibel level of 52. And just a frame of reference, a small AC unit right up against one is 76. the smaller units, the fan units that you might have on a house, a 76 right at the unit. They didn't have the more detailed information on the few I researched, but they would typically be just less than the 52, you know, in some range. And in fact, the large units right next to the large units are 84 versus 76 of the smaller units. So I mean, the larger units are definitely louder, but it gives you a frame of reference. And in a typical study, you would also have an ambient noise level of, say, the neighborhood at 3 a.m., 1 a.m. And those noise levels are typically in the range of 30 to 35 decibels for a relatively quiet neighborhood. And what I did was just take...
At what time, Mr. Dibb? I'm sorry. Do you mean at 3 in the morning, or?
Yes. Between...
Okay.
An actual noise study would measure ambient sounds between like 2 and 4. They'll physically go out and measure those sounds. And what we did was just using some assumptions along with the manufacturer's specifications. What we did was identify that the units at 50 feet, when placed on that roof area and surrounded by the parapet sound enclosures, will typically be in the acceptable range for an increase of noise. Basically, what the actual numbers, I'll run through them, but the HVAC units produce 52 decibels at 50 feet. The ambient sound is in the range of 30 to 35. And typically, when you design a parapet such as that at, there's another technical number, 5 pounds per square feet, if you purchase a manufactured sound barrier wall, that's the typical density of that wall. And that'll typically reduce noise by about 10 decibels. So what we have is it's producing 52, the ambient level's 30 to 35, but we're reducing it to 42, that 10 reduction. And just general regulations allow a maximum of about 10 decibels increase at the property line, which is, in that area, is close to 40 to 50 feet. So what I've just identified with some assumed values that we're in the acceptable range for noise along that property line. And furthermore, they've identified the nearest residence is the house on the corner over Eadsdale Road. That is newly added to that plan.
How far away is it?
That's about 95 to 100 feet away.
And that's the closest residence?
That's the closest residence. And we've also looked at elevations. Basically, the second, approximately, if you're on the second floor of that house, you have to look up to the parapet wall, which means the HVAC equipment is hidden behind that. So there should not be any direct line of sight, which is a major function of a sound barrier wall. You want it to be behind that wall. And again, you know, a similar development on this site could have 4 or 6, you know, more residential style units just sitting on a pad, you know, with some shrubs around it or something like that, which could, the combination of some other type development could produce as much, in general, could produce as much noise as these screened units. And again, we're proposing to provide a 6-foot parapet wall. I think you have this document in the packet that shows the height of the wall and the height of equipment. And we are proposing that specification, which is a typical sound barrier specification of 5 pounds per square foot on the density of the wall. That just means you're not just going to have a piece of ply. That wall, a parapet wall, is not just a piece of plywood. It's 2 pieces of plywood with some kind of insulating material in the middle. You know, it's a solid wall that's designed as a typical sound barrier. So if you have any further questions on
No, that's fine. Why don't you continue?
On the lighting,
Of the generator.
Oh, the generator is for emergency power backup, for life safety features, so and it does have some specific sound limiting enclosures and stuff, so unless the power's out, it won't be running at all, and even if the power is out, it's a generally quiet generator, so.
What do you mean for life-saving purposes?
Life safety.
Life-
The
Oh.
lights and the emergency lights and.
In emergency conditions, it kicks in. I thought you said life-saving.
I
was
might have.
wondering if somebody was having a stroke, whether the generator kicked in.
Yeah.
Okay. So why don't you continue?
Could you just tell everyone where the generator is?
The generator is that gray box.
So again, the generator is to one side of the service delivery entrance. It's on that side of the facility.
Marion, did you provide us with mini copies of these plans?
We did it, I can pull some more out. We-
No,
we
but I
did
just,
it- yes,
I know you were going to file them, and I'm not sure whether I,
You should, you should have copies, first of all, the PowerPoint you received last time had
Yes.
copies of the site
Okay.
plan. We've
That's right.
submitted another site plan this time with the materials you have
Yeah,
here
and
on
the-
sound.
great.
And also in the lighting plan, because we've added some
Second
things to
page,
the
yeah,
site
light.
plan.
perfect. Thank you very much.
If there's no other questions, I'll just move on to the lighting.
Lighting, please.
Just one quick question on the generators. The generator screened, or is the generator kind of out there?
The current plan, we aren't specifying whether it's screened, but we'd be more than happy to screen 3 sides of it with a fence or vegetative screening. Right now, it's just.
Well, it's in an area of vegetation.
Yeah,
Yeah,
it is in
so,
an area of vegetation
Why don't
anyway.
you vegetate?
Plus, that entire property line will have an 8-foot-high solid vinyl fence as well. So for the lighting, we supplied a photometric plan that covers the front parking lot. It consists of 12-foot-high poles, a residential lamp type style fixture on the top. It will not be a commercial-looking box. It is all proposed to be LED lighting on those light poles, so it'll be efficient lighting. The photometric plan does show that the light put off by those poles for that area of the parking lot does not overflow off the property. The lighting on the building will continue to be down lighting under the overhangs to light the patios. There will be a couple sconce-type lightings at the front entrance, and there will most likely be one on the Reedsdale entrance as well. In general, we're proposing to meet zoning bylaw on light overspill on lighting.
Can I just ask you, just want to make sure, am I correct that the yellowish areas in that parking lot, those little, that's where the lights are? Am I
Yes,
right?
those are the light locations. Those are newly added to that plan, just to show you that in relation to this GE lighting solution.
So there are 3 on the street side and 2 on the building side, is that right, of the parking lot?
Correct.
Thanks. Is there more to you?
Frank, do you have any questions on the lighting plan?
Nope.
Okay, I don't have any questions, Brian?
I do not.
All righty. Mrs. McGettrick, where do we go from here on your presentation?
Well, since you don't want me
Well,
to
in
give a
fact,
more
let me do
long-winded
this.
talk about
Let me
the
do this,
zoning.
since we've talked about the physical features and the various mitigation elements that the board requested. The board has no questions, but is there anybody out there in the audience who has any questions of Mr. Dibb or the applicant with respect to the lighting or the air conditioning or the other systems? Mr. Choi.
Just want to get up and just use
Of course you can. Yes, sir.
I'm just trying to make sure that I'm in context. I live on Wildwood Road, and I don't see that drawn in here. I think, that's Reedsdale. I think I know this house, but Wildwood Road,
It's way over, yeah.
and I'm just questioning whether or not the closest building on Wildwood Road, its rear, or whether that would be, exactly where it would be with respect to this patio and this enclosed area. I know that there's overlays that would include that. I think it would be helpful if I could see that.
These are the lots. So Hanwell Realty Trust is 30 Wildwood. James and Jean Connolly
Connolly.
are right here.
Okay.
So you're over here about, I think, but you're on the other side, but I
Yeah.
mean, yeah.
Yeah, then the Connollys.
So does that give you a better idea? See the,
Okay, and is there a scale on this? Is this a point of order? Is there a scale?
That's 1 inch equals 30 feet.
I'm sorry, I don't have a
get out of your way.
No, you stay there. You have a ruler?
I'm just trying to get a sense as to whether or not the back of these homes would be, I think you mentioned 90 feet, and whether or not that would be for about all these homes on Wildwood Road, or whether there would be, for example, the Hanwell's home, where that would be with respect to. Could you point out to me where on this plan this would be?
This rectangle right here is this rectangle. Okay. This property does go all the way back to here. These properties, I'm not familiar with how long these are out to this road.
They're not very long.
So, this is 90 feet from here to here. So, we're over 90 feet, even just to the property line. So anything.
Okay. And if I could, okay. I think I understand how that.
Okay, I think
we don't need it. If we do need it, I have a ruler.
Now, do you have any further questions, Mr. Choi? On the issues relating to...
Will those parking lights be on all night?
I would
Yes.
certainly say yes, because this is a facility where staff, come at different times of day. The parking lights are on the Randolph Ave side of the facility. They're not going to be visible from any of the residential properties in back, the ones that you're talking about, Carrie, but they will be visible, somewhat to the residential lot that's on the side that comes in and intersects with Randolph Avenue. There will be, this is a fairly minimal amount of lighting, and it will be at a 12-foot height. And the reason it can be that little is that there's already street lighting along both streets, which provides a lot of light. And the study that you've done has indicated that in order to have proper lighting, you will need these 5 12-foot poles with a single lamp on the top of them. But those are not huge parking lot lights, and they are not going to cast any light on the adjacent properties. You will be able to see light in the front of the facility. But from where you are in the back, and I know it's not just about where you are, but from that whole Wildwood Road back, you shouldn't really be able to see any light. And there isn't going to be any lighting of any significance. There's not going to be any external lighting around the other edges of the property at all.
Just one last point.
Yes, sir.
Could you point out to me, Mary Ann, or perhaps you should, where on the plan the trash is going to be stored?
It's right here.
Yes, it'll be right here on this side.
I was unable to see that.
Great, thank you, Mr. Choi. Does anybody else out in the audience have any technical questions? Yes, sir.
John
Why don't you-
Driscoll, 718 Randolph Ave. How close is that emergency exit? And is that right there at the corner of Reedsdale Road and Randolph Ave?
Yes, it is. It's up on the
Right here.
plan.
So this is right here, that would be right at the corner?
That exit is
right
here.
Close to the corner, yeah.
I do a lot of elderly places and they have an emergency exit, they've never used. They're all grown in with
Yeah.
trees and everything. This is right there at the corner. I don't know how they're gonna, I don't even know the reason why they want you to have it there.
It's solely for fire department access.
I understand, but when there's traffic, you know what I mean? I honestly think that could be eliminated.
The reason that we put it in was at the request of the fire department, but the reason was so they didn't have to turn their trucks around in the parking lot.
Oh, so they can come back out?
That's the only reason. Now, if they decided they wanted to turn their trucks around, you're right, we wouldn't have any need for that.
Right. And like I said, I can name a bunch of them, and they're all. Another thing is, I appreciate Ms. O'Brien asking all those questions, but if you look across at Tedeschi's, there's a big rubbish container sitting right outside. And my family lives at 399 Reedsdale Road, and I think that would be a great building for the neighborhood. And it's a first-class looking building, and she's actually gonna see more of this building than the Wildwood side. There's no issues whatsoever.
Thank you.
Is there anybody else who would like to be heard on the technical aspects of this particular proposal? Okay, so there's nobody, yes?
I just have one question. Who?
Sure, tell us, your doctor.
Dr. Richard Shea.
Mr. Shea.
Speaking as a town meeting member, looking out for the people who are abutting this.
Yeah.
I don't want any of these people lying in bed with a reflection of the light. And people went through this with the hospital, and now they lie in bed with light shining in. And there's not too much you can do about that. But now's the time to do, and we don't want them to lie in bed and seeing reflections of lights, whether you have to put up trees or whatever. I don't want those people subjected to that.
You can be assured that that's the foremost in my mind.
Thank you.
Having sat on a number of those hearings. Excuse me.
Okay, is there anybody else who'd like to be heard? And there is no such person. So, Mrs. McGettrick, let me just ask the board members whether they have any questions of Mrs.
I do not.
McGettrick or any of the experts who have appeared. There are no questions. So, Mrs. McGettrick, do you want to sum up, and we'll put this application to a vote? Oh, I'm sorry. Yes.
Yes, I'd like to be heard on something other than the technical issues.
Okay, so why don't we do this? Why don't we allow Mr. Choi to be heard so that Mrs. McGettrick can respond in your closing arguments? Mr. Choi, come on up.
Thank you. I didn't bring up this broader issue only because I thought that you were entertaining questions about technical
That's
issues.
all right.
My concern is long-term, and what I'm concerned about is if the business venture here by the operator doesn't work out, that the property will be sold or go up for sale. And in fact, because it'll be owned by a charitable organization, it may have actually less flexibility and may be more required to sell to the highest bidder, period, regardless of use. The parent company is Integra Medical Properties.
I'd like to correct you on that. Integra Medical Properties will have nothing to do with this facility once it's built. They're just helping with the permitting and construction. They're what do you call Integra? It's not, they're not going to be the owner. They've been hired to help with the development process and the construction of the building. Yeah.
That's right. But do they have a relationship with your entity at all? You're not owned by Integra?
No, Integra is just a separate company that's hired to do the help with the development.
Okay, Integra,
They will not be
Okay.
owners or anything like that.
all right, well then, if there's no relationship, my original understanding was that Integra was going to be, when you were, first approached the neighborhood, you told us Integra was going to be the moving force behind this. So, I looked up Integra and I see that it's described as it's a nationwide commercial real estate and investment firm, and it's for profit. And I don't quite understand the relationship between Integra and, there's a local LLC that was put in place to operate this, but I don't understand that. My understanding is a Massachusetts LLC, what the, who owns that in relationship to Integra. But I'll put that aside and get to my more important point, which is that I'm concerned about this eventually, this venture, which is going to, make money for the operator. If it doesn't make enough money, unfortunately, the way of the real world is they will have to do something about that. I hope it makes enough money, but they'll have to do something, and I'm looking long-term. I had requested that some consideration be given to putting in a covenant, which I raised at the last time, to keep the property residential or non-commercial, at least non-commercial. And I was told that, and I was talking about a 30-year covenant, I was told that that was not acceptable to the purchaser. And then I raised the idea, well, what about a 10-year covenant? Give us a 10-year breathing space so that if things don't work out, that the land couldn't be sold to the highest bidder, such as CVS, who may want to take on a zoning battle and may be well-funded enough to do that. And then I haven't heard the response, but I heard indirectly, and again, I know that the seller and Father Walsh has been very cooperative and concerned about the neighborhood, gave me some information I'd like it clarified about the bylaws of the foundation not permitting its sale to a for-profit. And I'd like just to hear a little bit about that, because as a member of the neighborhood, that would give us some assurance about the long-term implications of this project.
Okay, that's an excellent question. Do you want to address that?
Yeah, I actually have it up on the screen. It's our purpose section under Section C of our bylaws, and you can see upon dissolution, and if you read through it, and basically at the end it says that if anything were to happen, we would only be allowed to sell to another 501c3 organization as defined by the Internal Revenue Code of 1986. And then that actual bylaw is then also supported when we actually filed to be a nonprofit. So in order to be a nonprofit, to get your federal tax identification number, as well as then there's state charitable laws, this has to be a provision that is in there.
But as I understand it, that addresses the ultimate dissolution of the charitable corporation. That has nothing to do whatsoever with the charitable corporation deciding that maybe it could, sell this property, make more money for its charitable purposes, and sell it to a for-profit commercial enterprise.
So Section A of our bylaws basically says our corporation is in the mission to support end-of-life care for individuals with limited means, as well as to sponsor community education programs regarding end-of-life care and the role of hospice in that process. That limits us to our mission of doing exactly that. So getting into any kind of partnership or sale is disallowed, and in Section B, it basically talks about the remuneration of any entity, including its directors, cannot be for profit. So a nonprofit, the way that we are set up is our money goes to the mission. So we can never be incentivized for any reason whatsoever to just make money. We're driven by community donations in order to do our mission.
But as I understand it, you could sell the property and use the money for your charitable purpose.
I can, if I were to sell it, I could only sell it to another 501c3 charity.
Where does, may I just respectfully asking, I
Sure.
hope that's so, but where does that say that?
we are in business right here as the corporation's mission is to support end-of-life care. That's all we can do. We are absolutely limited by that.
But you can't sell property.
Well, look, I understand what you're saying, Mr. Choi, and I understand your interpretation of the bylaw, and apparently you differ on.
No, I'm just trying to find out.
Oh, I understand that. I understand your question, and I understand the bylaw, and I know how I interpret the bylaw, and I know how you interpret it.
I haven't, I'm learning, I'm trying to understand. I don't know that I have a set entrenched position.
Well, I think the problem, the protection you have, let me be frank, the protection you have under these circumstances, irrespective of how the applicant interprets its bylaws, is that if it were sold to a third party, then if they were going to use it for a use other than the hospice use, they're going to have to be getting permits for it unless they're going to do a single-family residence on it, and nobody would do that to this property. So if they're going to propose some type of multifamily residence, presumably they'd be back before the planning board. And if they were going to use it for some commercial purpose, they would be before the Board of Appeals. And I think the public boards may be your protection under these circumstances, and I understand that may not fully satisfy you, but I think we understand your particular concerns and the neighbors' concerns, and that's why we're here with this particular application, rather than having CVS or whomever you want to cast as somebody with deep pockets who will litigate forever. My only suggestion to you is tell you that we're not afraid of deep pockets. The town has deeper pockets and can litigate with anybody. We have battles with telecommunications providers that come in with the biggest law firms in Boston and take us into the federal courts, and they generally lose. And we have one case in the federal court now. So we're not afraid of litigation. Nobody's going to lie down and cast aside the community's best interests because they don't want a legal bill or they're afraid to go to court whether to win or to lose. But I think that's your protection here, the good judgment of the planning board if necessary, or the Board of Appeals on an application for a special permit or for a variance. And I understand your wish that you'd like full legal protection by a condition in the title to the property. We can't impose that on the applicant, and that's an area where we don't go. It's not within our jurisdiction. It's not within our authority, and it would be improper, in my view, for this board to try to put pressure on the applicant to put some type of a condition on the title to the property, irrespective of what that bylaw says, and to hold it against them if they didn't grant that condition. I think that's quasi-extortion. We don't do those things. You've got the purpose right.
Wait a minute.
Wait
a minute. I think you just suggested that I was.
No. I said if you'd listened to me, Mr. Choi, I said the board can't do that. You've got the perfect right to suggest that. We don't have the right to suggest that. If they wanted to voluntarily do it, that's fine. That's their corporate will. You've got the right to suggest it, and they've got the right to say no.
Just trying to raise what I consider to be long-term concerns, for the neighborhood, and
you may be right. You don't know who the board is going to be 20 years from now. I know we're not going to be here, and I don't know what the condition of.
Speak for yourself.
I am speaking for myself. Stop laughing, Father. But I'm saying that I think the boards in this town are really responsive to the town's best interest, and I appreciate your concerns. But there's only so far we can go. That's all I'm saying to you.
My last thing is just a point of order. These submissions are significant. I haven't seen them. I understand they were filed recently. I would like to speak to my neighbors and give them a few days to look at the submissions before the board takes a final vote.
I think the reason that we asked Mrs. McGettrick to file these materials 7 days before the hearing was not only to allow the board to do that, but to also allow the neighbors to come in and get copies of any of these materials. I also think, and I don't want to go to the transcript, and I don't want to sound overly pedantic, but I think I did say that anybody who did want copies of these materials, once they were filed, could either contact Mrs. McGetrick, and she said she'd be willing to send them to anybody who asked, or to contact Mary Fitzgerald, our clerk, and for a modest fee, whatever that may be, under the town regulations, copies of these would have been sent to anybody. So I understand your concern, but unless my board members here are concerned about the inability of the neighbors to look at the materials, the whole reason.
I've been in contact with Mr. McGee. I haven't seen them. I just haven't been given them. I haven't seen them. I didn't know they were on file, but, you know, I do recall you mentioning something to the effect that they would be available here. Frankly, just my own commitments at work, you know, I'd have to take time off to, you know, come in and do that. But I understand your point. I don't.
And I think it would be a burden to the applicant, to be frank, to come back here with all of their team and find out that none of the neighbors had any objections, and would have to continue it probably for a couple of weeks and not a couple of days. And so my view, unless my colleagues want to weigh in on this, is we should proceed with the hearing and proceed to the vote.
I agree.
I agree, but that, I'll presume to speak for my, it's not to say that we're not willing to sit here, and if you have specific concerns that have been raised during the course of this hearing that you can come up with now, we're perfectly willing to listen to them. I mean, certainly, I have asked some very pointed questions concerning many of the operational aspects of this thing. And quite frankly, I think that this plan has satisfied many of my concerns. I think the lighting is modest and not overwhelming, if not a little minimalistic. So compared to what I've seen, I see an effort on the part of the applicant to really minimize the impact on that side, the residential side of the property. There isn't a lot of lighting here. Most of the stuff that's going to cause a lot of noise is toward the noisier part of the property, if you will. I'm satisfied that there's sufficient screening and whatnot concerning the noise, the machinery, and the other things that are going to cause noise. I think it's a good plan based upon my experience in terms of its efforts to minimize the impact upon the neighbors. But I don't live there. You do. If you have a specific concern that we haven't discussed or we haven't thought of, I'm listen to it. And I think the rest of the board is as well.
I agree.
Well, look, I agree with that, but let me just say one additional thing. Is one of the beauties of the special permit process is it's modifiable. Not that you can pull the special permit, but if the lighting is not working, if it's adversely affecting the patients, if neighbors find that the lighting's intrusive when it was represented that it wasn't going to be, you or any person can come in here to the board or speak to Mr. Prondak in the first instance and seek modifications of some of these conditions. And so you always have that protection. This is not, for example, the lighting and the access, these are not conditions in perpetuity. They're conditions for as long as they're working, and if they're not working, they can be reasonably modified. And from my experience, under circumstances like this, the applicant usually works those out with any neighbors before any Board of Appeals hearings, and you have something that is an assented to modification of a condition.
I have a final question that I'd like to rely upon the board's expertise to comment on. We received information that if the special permit were granted, it would run with the land and would be recorded along with the deed, restricting use of the property in the future to its underlying residential zoning or a charitable nonprofit use as a hospice. And is that your understanding of what would happen with the grant of a special permit?
It's certainly my understanding, and my colleagues can speak for that, but I think that would be one of the, we talked about a sale of the property, that would be one of the the burdens that the applicant would have. If this hospice facility failed, then another hospice facility could open, but otherwise it's residential use, and nobody would pay the kind of money to put a single-family residence, even a McMansion, at this very busy intersection of the town. It would have to be some overly intense residential development, and you'd need all kinds of permitting, I think, from the board, from the planning board. Mr.
No, I
Curley,
agree.
do you agree?
I agree.
Do you agree with that?
Yep.
Thank you.
Okay, thank you, Mr. Choi. Mrs. McGetrick, do you want to sum up? Well, let me do this, just to be sure that we're perfectly fair. Is there anybody else who wants to be heard on this overall application? Okay, the record says no such person present. Mrs. McGetrick, the floor is yours.
Thank you. I guess in summary, what I'd like to say is this application for a special permit from the Board of Appeals has evolved from the first moment that Seasons started looking at the site and they saw the advertisement by the Archdiocese. And one of the earliest things we did was to try to meet with neighbors, and one of the earliest things, well, we realized, I think I already realized it, was that the neighborhood has had a tremendous concern with what happens with this site because of its location. In some ways, it's an attractive site for commercial development, but that would have significant impact on the adjacent neighborhoods. And so that was a key concern identified in our first meeting. We then went back and discussed with Seasons Hospice Foundation whether they would consider becoming the owner and controlling the hospice facility in such a way that it might be able to conform to the requirements of a special use permit. And it took a considerable amount of study and work by the foundation and its legal advisors and its staff to decide that this is an undertaking that they were interested in. I think they're very interested in it now, very excited about it, and convinced that they will be good community citizens, I guess, that they will contribute to the community not only through the direct services provided by the hospice, but through the education, the research, the volunteer program, and the special services and enhancements that they'll be able to provide at the hospice. Furthermore, because of some of the things that Mr. Hurley has alluded to, at this point, we don't know whether this facility will be subject to property tax or not. It will be a decision by the Board of Assessors. I think I alluded to that in my memo. And Seasons Hospice Foundation will do what the Board of Assessors decides it needs to do in that regard. If it's not subject to property tax, then they have indicated a willingness to discuss a payment in lieu of taxes program. They want to be good citizens, and they don't want to be a burden on the community. So, you know, it hasn't been something that we've been discussing at this hearing, but it has been an issue in the community. And it's a really difficult, this site is a difficult site, because some people in this community would like to see it become commercial and generate commercial property taxes. People in the neighborhood are very afraid of that and the impact it will have. This is the only proposal I've seen, and I've heard of a lot of proposals for this site, that attempts to serve both masters, I guess. In other words, it's not residential, it doesn't impose a burden, the type of burden that in one sense a residential property imposes on the community. It doesn't create, you know, children who have to go to school, although I love children and I have grandchildren in the schools, but it doesn't impose that type of burden, and it doesn't impose the same impact that, say, a full-scale commercial development would, like a CVS. In addition, it's a charitable, there's a charitable use here that will be something the community will come to value. And it will be a relatively quiet use and have, once it's built and in place, I think it will work very well here. And any smaller issues that do come up with the conditions that we've talked about obviously can be modified. So, you know, I at least have come to be convinced that this is a good solution for this site. We've had good feedback from the community informally on it. I think the details we've talked about, though, are what will make it work or not work. I hope we've addressed most of them, but we're certainly willing to address anything that the board wants us to. So I would appreciate your support. I hope the board supports this. Going forward, we certainly, as we've gone through the testimony at these hearings, I've tried to list possible conditions. I'm willing to give the board a list, or you may wish to just craft those yourselves, and based on what we've said at the hearings. I don't know how you want to proceed if you do decide to vote for the permit. So.
Great, well, thank you very much. Let me make some prefatory remarks, I guess, is the best way to put it. I want to thank Marion and your team. Mrs. McGettrick, I thought, did a wonderful job in this presentation. It was very thorough. It was very honest and honorable. She acted as an advocate, but at the same time was very fair in answering all of the board's questions and the concerns of neighbors. And I certainly appreciate the participation of Mrs. McGettrick and her team in dealing with other town agencies that don't have direct jurisdiction over this special permit, because I think it's the way to do it, and I think it was done very, very well. Thank you. I'd also like to thank the neighbors, Mr. Choi in particular, but all of the neighbors who participated in the hearings. I'm always struck by the good faith and good motivation of their questions and their positions, even if they don't agree with the application or even if they don't agree with the board. I think it's very healthy, and it was very helpful to allow the board to consider all of these various aspects of the application. So since I've run the hearing and I've talked too much, and I'd also like to thank those neighbors who didn't speak and who were just here for support, one side or the other. We appreciate your presence. It's almost 10 o'clock at night, so we thank you for staying late. So I've spoken too much since I've had to run the hearing. Let me hear from my colleagues, and I'll try to put in my 2 cents at the end of all of this. Mr. O'Brien, please.
Thank you, Mr. Chairman. Just to repeat a couple of your remarks. First of all, I think the applicant had a very well thought out, well put together presentation. I thank the applicant for making the board's job easier in that regard, particularly by providing the necessary experts, the engineer, et cetera. I too also want to add my thanks for Mr. Choi, the other neighbors. Again, I have not sat on this board as long as I hope to sit. Maybe we'll be here 20 years from now, but
I hope you are.
I continue to be impressed by the passion that the citizens of this town have for the town and the desire to see that it improved and maintained, and I appreciate that. I think that this is, I think that this will be a benefit to the community. At some point in time, we'll discuss our positions on the special permit itself, but I look forward to the process, and I also look forward to the discussion concerning the conditions we seek to impose upon this. So.
Okay. Mr. Hurley.
I agree with all of those sentiments. I think this is a logical use for this site. I struggle sometimes with the zoning bylaw in this town. You know, I'm a bit of a zoning purist. And I struggle sometimes when I think that things are coming before us that properly should be before the town meeting, but leave that, be that as it may. I've been persuaded that we have authority to grant the special permit, and just to jump ahead a bit, I would be inclined to vote in favor of granting the special permit. I would incorporate, without reciting them at length, I would incorporate all of the various suggestions and proposals that are in the various submittals that came to us came to me in this lovely blue package at home recently. I think they were well done, and I think we could use those as a basis to craft the conditions relating to trash and sound and lighting and the rest, all the topics that we've discussed. And I'd be happy to see either John or Frank draft those conditions as part of a decision and look at them carefully when they're done. But I would vote in favor of this, having forced Marianne to go through all sorts of reading of cases and summaries of cases. I've been persuaded that we can do this, and I'd be inclined to vote to grant the special permit.
Thank you, Mr. Hurley. My thoughts are when this application was originally presented, it seemed to be taking the approach of maybe this is the lesser of two evils. We have commercial development and large residential development, and maybe we should go for this use. From my view, this is not the choice of the lesser of two evils. This is the best choice for this piece of property that I've heard proposed in the last 2 years. This is, it's consistent with the prior use of the property. I hadn't realized that religious services were actually held in this property before St. Elizabeth's was built. It's a wonderful use. It's certainly, it's a unique facility. There's no facility in the Boston area like this particular facility from the testimony. It is a charitable use, whether it makes a profit or not. I think, from my view, I was particularly struck by the testimony of Ms. Bliss, to be frank about it, who talked about this facility as, she said it's teaching people not the art of dying, but the art of living their last days. And at the positive approach that this facility has to people in their final days. And I can't think of a more noble use, a more charitable use than something like this. And in addition to that, the applicant is a charitable organization, and they're requiring the proposed operator to fulfill charitable obligations, including taking people who don't have the ability to pay. So when you look at the location of this property across from St. Elizabeth's Church, and in location proximity to the hospital, this is an ideal use of this property. It's a less intense use of the property, it's a quiet use of the property, and I think it's a noble use of the property, and I really am impressed by the fact that this is just not a facility where people end their last days, but they ended in dignity and in the best possible mode. I won't get overly sentimental about people dying. Father Walsh, he sees this all the time. And it seems to me that Ms. Bliss told us this is a group of patients that have slipped through the cracks. And so I think this is a great use of the property. It promotes the community. It's a benefit to the community. And it also protects the neighborhood. And not in perpetuity, but we hope it does. In my view. I think the applicant has been thoroughly cooperative in allowing conditions to be imposed that are reasonable, fair and reasonable. I'm sure the board members can reach final agreement on these particular conditions. And if perchance they need to be technically adjusted, we have the perfect right to do it. And if some of the neighbors find that the lighting is offensive, or for some reason the noise from the air conditioner is too much, to me that's really nitty-gritty as opposed to what this facility is all about. And the board is your protector under these circumstances, and we will protect you under these circumstances. But with this particular applicant and the intent that they've demonstrated, I don't think you're going to need that type of protection. So I think that this is a terrific use for this site, and I hope that I should say it's kind of ironic here. It's the applicant has found the town to propose this use and then to advocate the use, when maybe the town should have gone out and tried to find this type of applicant for this type of property. And you wonder when you see churches closing these days, what a wonderful use if the Archdiocese could propose that some of these churches that are being closed could be converted to this type of use rather than developed into condominiums for for wealthy young lawyers and executives. But who knows? That's maybe going a little far afield, but I think it's true. I think it's absolutely true. So I intend to vote for this application with the variance, the conditions which we've discussed, and I'm sure the board will come up with proper language that will everyone will feel comfortable with. And do you feel comfortable with that, Frank, as opposed to going through all of the conditions and the terms of these conditions here and now? We can do that if you want to, but I think we have reasonable consensus on the conditions.
Well,
And we'll tie those conditions
Right,
into the plans.
Right. I'm prepared to support this. I agree with everything that my colleagues have said about this. I believe that the conditions that the applicant has put in the materials are acceptable. We have long experience in terms of dealing with the nitty-gritty. We can use your trash memo and your lighting memo and the other stuff. We can certainly do that.
You sound like you're volunteering to write this decision.
Well, I think I kind of have. The other thing, though, is that given the interest of the neighbors in this, and not wanting to, be opaque about this, but also mindful of it being 10 o'clock at night, I think it just might be useful in terms of just a general overview of the type of conditions that we're thinking of putting in, so that we can kind of let folks know what our thinking is. Of course, if you've been sitting through the hearing, I think you kind of have a good sense of where we're going here. But I just think it would be worthwhile taking 10 or 15 minutes just to run through a general overview of the conditions.
You want to, that's fine if we want to do it. The other alternative, the conditions have been discussed, and I'm prepared to do it. The other alternative is just to prepare a decision with the conditions in it, and the board can go over those conditions and make sure we're in agreement.
We have to have a public meeting, not a public hearing to do that. I was thinking,
Yeah,
why not do a draft decision and give it to the neighbors before we sign it? And see if people have any input on the conditions.
Well, I don't think that's advisable, to be frank about it.
All right.
I think the board should make its decision on the conditions.
Okay. Well, I mean, we either have to agree on it tonight, or we'd have to come back and have a public meeting, not a public hearing, to discuss the decision.
Okay, well, let's agree upon it tonight, and we'll do it here and now, if that's what everyone wants.
Okay. Not necessarily what I want, but I don't...
Well, I understand it too. I don't think I want it. I think that, what are we going to do? We're going to talk about the trash receptacle being as shown on this particular plan, and...
Well, I mean, basically what I'm thinking of is basically accepting the recommendations that have been placed in the memo, which are graphically represented here.
Yep.
With the trash receptacle being located here, the generator being located here, appropriate screening, the lighting being essentially in conformance with the plan, with the technical specifications, the noise area up here with the parapet and the noise screening for the air conditioners. The trash pickup, delivery limitations, essentially normal business hours.
Normal business hours,
Normal
sure.
business hours type things. And leaving to the discretion of the building commissioner as our first line of defense, as the zoning enforcement official, any decisions involving necessary modifications to this. For example, I mean, probably not, is there a hidden gas line here? So you don't want to, you don't want to put the dumpster right there, or other modifications that may need to take place during the course of a construction issue comes up. Well, I mean, one of the general conditions would be that the building would be constructed in general conformance with the plans on file with the board. So the big thing for me is what I see is what I'm going to get. And if I get something that I haven't seen, I'm not going to be happy.
I don't, from my perspective, I don't disagree with anything you've said. And I think that most of our decisions, we do tie our decisions in to particular plans, just as we're going to suggest that the property under this special permit is going to be constructed in substantial conformity with these plans, and we're not going to get a different building. And if we put in there the discretion of the building inspector to modify the incidentals of these conditions,
Right.
I think we have all of the protection that we need. Do you want to be heard, Mr.?
No, I agree. I agree with what you both said.
I'm sorry? Is there any question on these conditions or comments? And yes, sir. Doctor.
Well, one benefit we have the fellow who is going to be involved in building it is an Oldfield, so we know where to find him. We don't like him.
Well, I didn't realize that. So all of those members of the board who are in favor of granting this special permit with the conditions that we've discussed and will reduce to writing with the component of the building inspector's involvement, say aye.
Aye.
Aye. Well, congratulations on your special permit.
Thank you very much.
Marion, just for the record, in terms of the process here, if it took us a couple of weeks or so to crank out this special permit, is that consistent with your planning and closings and
Of course,
construction schedule and all of that?
yes.
Okay, great.
It's very helpful to us that you've been able to arrive at a decision tonight. But in terms of the time it takes you to write that, whatever you need. Thank you very much.
Thank you, and thank you all for coming tonight. Thank you.
All right. I'll write it.
You want to write it?
Yeah, I'll write it.
It's perfect. You have all of the materials. Make sure you've got a complete.
Now is the beginning of the really hard part.
Got all of.
Oh, yeah, we're just getting started.
Yeah, I've got all the stuff, and then